Who's Ray? And what's this drink he's sipping? Well, in just a minute, I'll explain. There is a doctrine in the law called res ipsa loquitur, and it sounds like re sips a loquitur. So it sounds like somebody's sipping on a drink, but that's not what it is. Res ipsa loquitur means the thing speaks for itself, and it's a rule in tort law that allows a plaintiff to show certain things and avoid all of the requirements of showing negligence. Now, in a negligence action, normally somebody has to show that a person has a duty to protect the other person. For example, a physician has a duty to exercise due care in the care of a patient. That duty is placed there by the law. That duty is a legal question. But not everybody has a duty. For example, in a situation where somebody is swimming out in the lake and they start to drown, there is no common law duty to rescue. And no one can be sued because they don't go to rescue that person who's drowning out there in the lake. So questions of duty are an important thing that res ipsa loquitur does away with. Under this doctrine, all a plaintiff has to prove is that the event that happened is the kind of thing that doesn't happen in the absence of negligence. For example, a pallet falling off of the rack at a warehouse club like Costco or Sam's. If it falls off and clonks somebody on the head, that's generally the kind of thing that doesn't happen in the absence of negligence. That's one of the reasons why they close off those aisles when they start moving things around, because they want to prevent that. That's why it's one of the things that doesn't happen in the absence of negligence. The other requirement is that it has to be, the thing that causes the harm has to be under the exclusive control of the defendant. Meaning it's not something that is shared by the plaintiff. So, for example, in the warehouse club hypothetical, the warehouse club clearly has control over its own shelves. And that's so because it has that exclusive control, the doctrine would apply. And then the third element is just that the harm that befell the plaintiff is caused by the fact that, they were injured by the thing that was under the control of the defendant. So if you satisfy those three things, then you don't necessarily have to prove the specific acts of negligence. It's a presumption that arises in the law. Res ipsa loquitur is Latin, and like I said, it means the thing speaks for itself. But it's not a panacea. It doesn't always work. And in fact, frequently, it is a doctrine that has been cut back significantly by appellate courts, because it tends to be somewhat unfair to the defendant, particularly when there is no real information about what caused the harm. All of the foregoing is said just for the purposes of education. It's not legal advice, and you shouldn't take it as legal advice. If you need legal advice, you have to see a lawyer in your jurisdiction, just the way my little movie at the end here tells you. So if you found this information helpful, I hope you'll smash the like button and click on the notification bell so that we will be notified every time I post a video. Thank you and have a terrific day.